Alex here with part 145 of the My Docket series on child custody and visitation. As my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. At this point, I am filing my reply to opposition to a motion for leave of the court so that I can conduct some limited discovery. I can't really think much about my mindset being any different than it was in the previous video, which wasn't completely negative or completely positive. And as I mentioned, the most important thing was that I wasn't surprised by my ex's opposition. So I dealt with the anticipated arguments in my reply. Basically, she went the exact route that I expected her to go, and I went ahead and replied the exact way that I anticipated I would reply. The only thing that's different about this situation is that I hire an attorney, and this is the most expensive attorney, I guess you could say, that I used in this case. Now that I think about it, I think this is the only attorney that I paid, because I had help from from 3 friends, and I don't think I paid any of. Yeah, I didn't pay them. They helped me for free. So this attorney I'm going to talk more about during the aftermath with regards to the expenses. The only thing that I will mention is that my wife had a role to play here. I remember my wife being concerned. She was the one that kind of gave me that nudge to file. I was already going to file the motion to modify physical custody, but she urged filing it sooner than I would have. I wanted to wait, and she wanted me to file it then and there. We came to the point where she was concerned that this was not a hearing, that I should go it alone. And I do have to say, had I gone it alone, I still think I would have won, but I don't think I would have won on all 5 issues. I think that the judge would have probably done something that I explained in the video, meta rulings. I think it helped a lot to have the attorney in the sense that I took an already amazing case and I gave it to a professional, to an expert. And so I ended up winning on all 5 issues, and that was the only time that happened in the, in all, however many years it's been litigating at this point. I think it's been 5 years. My wife did have a role to play there. She also helped, I have to say. And I hear a lot of times people do this and it doesn't work out. I hear a lot of people will get money from their boyfriend or a girlfriend or a wife or husband or like a family member, and they won't really get a good outcome. They might get a few things. They might have survived. But in this particular situation, it was that kind of rare situation where my wife contributed to the attorney fees, and I ended up, hugely benefiting from it. So that's another positive note, that she really helped me out, not just with the sort of urging that I filed the motion, but also with the finances. And that's the only time I ever had any help financially from anyone. That's the only time ever since and up to that point. And I have to say that the one time that I did accept some money, I put it to great use, and I secured an unbelievable outcome. I can't imagine how the outcome could have been any better in any way, shape, or form. We'll talk about that more when we go to the actual hearing video itself. So I think all of these things being said, we should really go ahead and get into what I have filed. Here we have my reply to opposition to motion for leave of the court to allow limited discovery. Scrolling down, I'm the petitioner, identifying myself as the petitioner to the court, indicating that I am not, or that I'm appearing in proper person, which means I don't have an attorney. I know I mentioned earlier that I do have one, but it's not quite yet. It's going to pop up later on in this video, so just hang in there. And that I'm filing this reply to my ex's opposition to motion for leave of the court to conduct limited discovery. First paragraph. My ex does not appear to argue any lack of relevancy on my requested discovery, but rather she's arguing that the decisions of the Child Protective Services Agency should have preclusive effect. I've talked about this before, and I will talk about it again. That is not a defense. Just because the decision was made by CPS doesn't mean you can't bring it to your child custody judge. And the reason why is because of a doctrine called issue preclusion. It's one of two, actually I think the doctrine is called res judicata, and one of the two species of res judicata is issue preclusion. You can learn a whole lot more if you watch the videos issue preclusion and claim preclusion. Those are two separate videos. Anyway, my ex has failed to cite any points and authorities regarding her arguments, and for that reason, her arguments should be disregarded on that basis alone. She's in violation of DCR 13 subsection 2. It's pretty ironic that the attorney is the one that's not following any laws at all, and I'm the one that's actually citing statutes, rules, and case law. I've told people many a time, if you think that attorneys love laws, you're sadly mistaken. What attorneys love is their relationship with the court, their relationship with opposing counsel. The laws anyone can use. There's nothing remarkable about the law to them. Any random nobody can walk into court and use a law and win a case. What's remarkable for them is winning because of their relationship with the judge, the fact that they're friends with everyone, stuff like that. So this is not surprising to me that my ex's attorney isn't citing any laws at all, and she's just basically blurting out why she should win. And I, the non-lawyer who never went to law school, is citing statutes, rules, and case law over and over again. And I do this, and it leads me to victory. But anyway, we'll go ahead and continue. So her failure to cite any points and authorities should be treated by the court as an admission that her arguments have no merit. And that's why I'm hitting her on DCR 13-2. I have repeatedly stated that the tactic unfairly prejudices me because I have to guess by what authority my ex is asserting. And this is true. When my ex's lawyer doesn't assert any authority, when she just says things, now I have to go and try and figure out what it is exactly that she could, under the law, be correct about. And that's not fair. That's prejudicial to me. And according to DCR 13-2, she should be punished for it. I'm going to go into the next assertion here, which is that res judicata consists of claim preclusion and issue preclusion, and that there are tests to how these work. I think I discussed claim preclusion first. You can see that there are 4 elements to how claim preclusion works. If not all 4 are satisfied, you cannot use claim preclusion. And I go ahead and I discuss in the next section why claim preclusion does not apply. After that, I tackle issue preclusion. Once again, we have some elements here, not 4, this time it's just 3 elements. My ex has to show, number 1, that the issue was decided in a prior litigation, number 2, that the initial ruling must have been on the merits and become final, and number 3, that I was a party or in privity to that prior litigation. So this isn't litigation. A CPS agency's report, that's not litigation. So number 1 doesn't, get satisfied. Even if it was somehow considered to be litigation, number 3 wouldn't be satisfied because I wasn't even a party to the process. My ex filed, or whoever it was filed a report against my ex. I wasn't a part of that process. I didn't get to provide input. I didn't get to testify. I didn't get to provide evidence. So number 1 and 3 aren't satisfied. I don't even know if we can call it a ruling. I mean, I really struggle. If you read that decision from CPS, it was a single page piece of paper. It wasn't even more than 3 or 4 sentences. They basically said that there was nothing for them to look into. The end. They didn't cite anything, any facts, any evidence. They didn't mention how their investigation went. There was nothing there. So issue preclusion is not satisfied. If there is no issue preclusion and there is no claim preclusion, then there is no res judicata, and you can't block me from bringing this issue before the court. If the judge doesn't believe that, I can take him to the Supreme Court of Nevada and have him educated on that. Luckily, the judge didn't buy my ex's argument. So we're going to go ahead and move into the next section here. Not only is there no preclusive effect by CPS's determinations, there is also no way my ex can invoke privilege. Privilege is the other way for her to block this from coming before the court. Nevada Revised Statute 432 subsection B255 states, according to the legislature, that any proceeding where such a report, and they're talking about CPS reports, or the contents thereof is sought to be introduced into evidence, such a report or contents or any other facts or facts related to thereto with regards to the condition of a child who is the subject of the report shall not be excluded on the ground that the matter would otherwise be privileged against disclosure. They want these issues to go before judges. The Nevada legislature does not want this stuff kept secret. They don't want attorneys sweeping it under the rug. The legislature has taken deliberate steps to enact this, quote, admissibility of evidence, unquote, statute, precisely because the legislature wanted to ensure that children would be protected by allowing evidence to come to light in any proceeding. So there I am trying to get evidence before the court, and there is my ex and her attorney trying to hide the ball, sweep it under the rug. They don't want the court to look at it, and they know that's because the evidence would be damning. Let's go into the next section here. In this, it is the duty of this court to get to the bottom of questions concerning the potential abuse and neglect of a child, especially where, as in this case, the child's first grade teacher reported a call back from CPS indicating that they couldn't even find my ex. Why couldn't they find her? If you want to know the answer to that question, you can read Falcone v. Secretary of State, 129 Nevada Advanced Opinion number 28. The Supreme Court of Nevada will explain to you exactly why somebody like my ex can't be found. And if you want to know more about the confidential address program, you can also watch my video, Right to Know Where Child Resides. Going into the next section here, any evidence that is relevant, okay, hold on a second. There's two statutes here. I know there are. It looks like I just cited one, though. So there's one statute that discusses relevance of evidence, and then this is the second statute that I usually bring up, which states that evidence is relevant if it is likely to make the existence of a fact more or less probable. So these reports are definitely consistent with all of the laws. My ex's attorney hasn't cited any laws at all, which is why, pursuant to DCR 13.2, the court should just reject her arguments straight away. But I go ahead and hit her with 5 or 6 different statutes supporting why I'm right. Next assertion here is that my ex improperly argues the, quote, heightened potential for abuse, unquote, standard. In reciting Rule 16.21, for there to be actual abuse, my ex has to demonstrate precisely how the discovery is going to burden her. However, I haven't requested any particularly burdensome discovery instruments, which is true. I could have asked for requests for admissions. I could have asked for interrogatories. I could have asked for requests for the production of documents. I could have asked for a deposition. All of these things would create more work for attorney and rack up her attorney fees. I didn't ask for any of those things. The only things that I asked for was some subpoenas, ducas tecums that I wanted to issue. The only work that she would have to do is file a motion to quash if she felt that they would be quashable. If she didn't feel that, she wouldn't even have to do anything. So I chose the least burdensome instruments that I possibly could have chosen, and she still went ahead and, to my opinion, in my honest opinion, abused Rule 16.21. Well, she tried to abuse it. She failed because the judge is going to reject her arguments here as well. Going into the next section here, Max argues that Statute 432B, subsection 290, E, allows the court to review the details of my request in camera. That's an acceptable request. I go ahead and concede that. If the court determines that the information in any of the reports should be explored further, then I am going to request that the court review these documents in camera pursuant to the law. Going into the next section here is my declaration, and this is me swearing under penalty of perjury that all the facts alleged in this reply are true and correct. And then here we have Rule 5, Certificate of Service, where I am indicating to the court that I serve this document upon my ex's attorney. Next document, request for submission. I've talked about these many times. If you want to learn more about the request for submission, please watch the video, request for submission. If you don't know what this is by now, then you probably aren't watching the series from part 1. I strongly recommend you watch from part 1. Next, we have Rule 5, Certificate of Service, indicating that I serve this document as well upon my ex's attorney. Here we have a proof of personal service. This is a process server that I used. She served a true and correct copy of this subpoena, or we're about to get to the subpoena, guys, hang in there, of the subpoena ducas tecum upon the teacher, Jennifer Williams, and then also upon the school dean, Mr. Tekken Tunser, and then also upon the dentist, Dr. Luz Molina, and then also upon the other dentist, Dr. Melissa McCool, and then also upon who's this Christy Candor. I'm not sure who this person is. We'll take a close look when we actually get to the subpoena. And then one more right here upon Leah Shebler, the dental hygienist. So this process server served all of these witnesses. Why didn't I serve this one myself? The reason is because the rules say so. Rule 5 will allow me to serve my ex myself through the mail or in person if I want to, but it only applies to certain things. Rule 5 does not apply to subpoenas. I cannot use Rule 5 to serve a subpoena. I have to use the rules under the subpoenas section of the Nevada Rules of Civil Procedure to serve this document, and it says in that rule that it has to be done by a third party and that they have to be served personally. So I personally can't be involved in the process, nor can I mail the document to them. Next assertion here is the Certificate of Service under Rule 5. This is a document, let's see who's doing this. This one's me, and I am stating that I served these documents upon all of these witnesses as well. So it looks like I went ahead and gave them 2 different forms of service. Oh, no. Sorry, guys. I served the copies of these subpoenas to my ex's attorney. That makes more sense. So the copies of the subpoenas that were served upon those actual witnesses were also served upon my ex's attorney, so she could be aware of the witnesses who I had subpoenaed to appear in court. Next document We have the notice of appearance. We have attorney Marilyn York in Reno. She's a well-known father's rights lawyer in Reno who is making an appearance on my behalf. She's indicating to the court that going forward from this point in time, she will be the attorney of record on this case. She will be filing all papers and pleadings. She will be accepting service on my behalf, and she will be appearing at that hearing to testify, or not to testify, to argue on my behalf in this case. Next, we have the certificate of service under Rule 5 indicating that Marilyn York is indicating that she has served this notice of appearance upon my ex's attorney. Next, we have the proof of personal service. This is a document signed by my ex indicating that she served this document upon Dr. Richard Adams at his place of business, the Smile Shop. And this is probably a subpoena. Okay, so it's just another subpoena. Next assertion here is, okay, so now we're getting to the actual subpoenas, guys. I want you to know that even though these have popped up right now in this case, they were actually served quite a while ago. So my attorney wasn't involved in the drafting or in the serving of these subpoenas. It's just that they are popping up now in the case because they're actually being filed with the court and they're being served. So first we have Dr. Richard Adams. I am commanding him to appear at that hearing to testify as a witness on my behalf. And then you can see here the instructions to the subpoena. If you want to learn more about subpoenas, definitely watch the video on the topic because there are a lot of details as to how these work that I'm not going to mention in the My Docket series because I've already got a video dedicated to the topic. And then the last section here is a Rule 5 certificate of service indicating that this document was served upon my ex's attorney. Next, we have the subpoena commanding Leah Shebler, the dental hygienist, to appear in court and testify on my behalf. Same thing for pages 2 and 3. Next, we have the subpoena commanding the dentist, Dr. Luz Molina, to appear in court on my behalf and testify as an expert witness. Pages 2 and 3 are again the same. Next, we have the subpoena commanding Jennifer Williams, the teacher, to appear and testify on my behalf in court. Same thing with pages 2 and 3. It's the instructions and the certificate of service. Next, we have the subpoena commanding Mr. Tekken Tunser to appear and testify on my behalf in open court. He is the dean of the school. Next, we have an order from the judge referring my motion on discovery to the discovery commissioner. If you want to learn more about how the Discovery Commissioner works, you can watch my video on the topic. It's titled Discovery Commissioner. If you have been watching the My Docket series from beginning to now, you would have already seen that I went through one of these hearings with the Discovery Commissioner already, and that the hearing went really well. It was a phenomenal experience. He was very professional. He was completely different, not just from the first judge in my child custody case, but even from the second. The way that he approached the case, the logic that he applied, the wisdom that he showed from the bench, completely, it was a night and day difference from how this judge operated versus how the family division judges operated in this case. I'm not going to use that necessarily to say that it was, it's very difficult for me to not make that sound negative. But that's not my intention. I guess that's all I can really say right now. My intention is to have a tone that is matter of fact here. But I mean, I guess my viewers are going to take that as they will. So he is referring this to the Discovery Commissioner. He's citing Rule 16.2 subsection 2, D1, which allows him to do this. And then the next page of this document indicates that he has served this document to my attorney and to my ex's attorney. He also has sent it through interoffice mail to the Discovery Commissioner himself. And then the last document in this video is going to be the order to set hearing regarding request for judgment. The judge has reviewed my omnibus motion to reduce arrearages to a judgment and my motion to compel or to have my ex held in contempt of court again, and my motion to modify timeshare and for an order to email vacation requests and to restrict certain communications. And he is going to set a hearing on this matter. He has also indicated here that he has reviewed my ex's surreply regarding dental expenses filed on February 13th, 2014. He is also saying that he finds now that we share a minor child. This is a standard summary paragraph right here at the bottom of the page. We have the joint physical and joint legal custody relationship, which is the status at the time of this order. And then in the next assertion, he goes into the order after hearing filed May 26th, which discusses the 30/30 provision, which is going to basically control how and when I get my arrearages on that judgment for all that medical arrearages. Next assertion here, he's talking about the motion that I filed on October 28th. He is recognizing that I have alleged issues regarding our son's dental surgery and that she doesn't want to pay the bill. And then there are some disputes here as to why she doesn't want to pay the bill. Going into the next assertion here, he is recognizing that I have claimed that I sent my ex demand letters for her portion, and he goes into the actual letters, both Exhibit 7, Exhibit 8, and Exhibit 9 of, and Exhibit 11 of my motion, or is it the letter? In any event, I don't think he attaches exhibits to this order. I think he's referring to exhibits that I have filed. If he is doing that, then you've already gone through them because you've been following me through the series, so I don't have to go over them again. Here we have my argument. He's recognizing my argument that my ex's failure to reimburse me has forced me to pay the entirety of the bill. Next is the opposition that she has filed, where she is, for the most part, bringing up a bunch of excuses as to why she doesn't want to pay. Next assertion here is that my ex is claiming that I failed to properly notify her regarding the details of the dental procedure, which doesn't really control on this issue anyway. Next assertion here is the request for reimbursement that I'm making regarding the dental cleaning. My ex is noting that the dental cleaning charge is higher than a previous bill, and she's trying to say that it's not covered by insurance. Next assertion here is that my ex is reiterating she never agreed to have the dental surgery performed on the minor child. She's arguing that I should pay the entire amount because I refused to cooperate with her by waiting. By refusing to wait, because she wanted to wait. Next assertion here by the judge is that in my reply, I'm arguing that Dentistry for Kids is an in-network provider and that the affidavits of two different people support my arguments, which are that it's not really an in-network or out-of-network care issue. It's an out-of-pocket expenses issue. There's a difference between out-of-network and there's a difference between out-of-pocket expenses. They're not the same thing, and my ex is trying to conflate these two things. I'm arguing that I do not have to provide my ex with an EOB. This is just the most ludicrous statement ever, because my ex already admitted in the last hearing that this is not something that I was going to have to do anyway, and this should be in a written order too. Next assertion here is that my ex's argument that the court's order after hearing entered May 26 requires me to pay non-covered medical expenses would be in direct contravention of public policy and void under Nevada law. This is true. Even if the order did say what my ex is saying it says, which it doesn't, even if it did say that, it would be in violation of the law and totally flagrantly wrong, because the legislature specifically stated when they enacted that statute that parents have to equally share the costs of these expenses, with rare exceptions. There may be something in there for people that would suffer financial hardship, something like that. In any event, I'm not even sure about that. I don't even think my ex raises that, because she has a job that pays her more than I earn. So for her to claim, that would just be crazy. For her to claim that she's going to suffer hardship when she makes 2 to 3 times as much as I do would be the most ludicrous thing she could possibly state, which is probably why she didn't state that. Next assertion here is that I'm arguing my ex wanted our son to sit in pain for the mere possibility that she might obtain better coverage, which is true. And then I go into, or the judge goes into the law that I cite, which states that that I'm not required to receive consent prior to surgery, which is true. There is a law that says that I don't have to do that. All I have to do is cite the law, and just like that, she's ordered to pay half the amount. Next section here is that my ex consented to the surgery, which is true, and that I claim that the affidavit of Wyatt Smith attached here to as Exhibit 2 is attesting to that fact. Next we have my ex's characterization of, let's see here, my email as threatening imprisonment. All I'm doing is placing her on notice as to how contempt of court works. That's how contempt of court works. If you violate the court's order, you go to jail. They can also fine you, but they can jail you too. So anyway, that's legal threats are totally legal. It's not like you're threatening to beat somebody up or kill them. It's just a legal threat. That's what the law is there for. Anyway, next section here. And if you want to know more about my thoughts behind that principle, take a look at the video Control, because I talk about it. I mean, there's two sides to the coin of control. It's not so simple as a lot of people try and make it seem. And that's a video that I highly recommend people watch. I'm requesting that the court disregard my ex's assertion that I violated the court order because it's a tactic. Yeah, he puts tactic in quotes. It is a tactic. If there is a violation of a court order, she needs to file a motion. That's how it works. Next assertion here is that pursuant to the law, my ex is precluded from challenging my request for judgment because she failed to request a hearing within 20 days. That's right. That's what the law says. And then I go in, and the judge goes into the next section, which is in my reply, I'm indicating that I recently received an insurance overpayment, and so that way that money can come out of the amount that she needs to pay. So I'm admitting this. Next, we have allegations regarding the surgery being performed by an in-network provider, and that my claim that my ex is precluded from challenging my request was raised for the first time on reply. The court granted my ex leave to file a surreply. Okay, so the judge is saying that he thinks a hearing is appropriate, or he's going to consider whether it is. We already know he's going to do that. Pursuant to the order allowing surreply regarding dental expenses and denying other requests, filed February 3rd, the court granted my ex leave to file a surreply addressing claims raised by my ex for the first time in reply. In her surreply, my ex argues that the issues before the court are whether sufficient and timely communication between the parents regarding the treatment plan was made, how the treatment was to be paid, and why the communication breakdown took place regarding the actual procedure. My ex acknowledges that the parties attended the initial appointment for the minor child at Dentistry for Kids. The My ex alleges that the parties were informed that the minor child's teeth needed to be cleaned prior to surgery. My ex argues that it is obvious that I am taking the firm lead in scheduling appointments. My ex is reiterating that she made it abundantly clear that she was unable to afford the procedure. My ex, which is not relevant to the law. My ex is reiterating that I have insisted that my wife's insurance would cover the cost of the procedure, which is a lie. My ex is reiterating that I consulted the dentist and made all appointments without timely notifying my ex, and she's also arguing that I arbitrarily set the date of surgery. Next, we have regarding the allegation that a bill is proof of payment. My ex argues that the fact that I paid upfront does not indicate that my ex owes half the amount that I paid. She reiterates that I dictated all aspects of the dental treatment without taking into consideration her objection that she could not afford the surgery. And then we have the law, which my ex argues that the statute does not apply because there is no judgment in this case, which is completely wrong. The Supreme Court has stated this before, that a child support order is a judgment as a matter of law. So it's like she's living in a fantasy land. Let's go into the next section here. My ex argues that my interpretation of the law is flawed and that the court does not have to order parties to equally share expenses when there are extraordinary circumstances. Okay. Have you learned about the plain language rule? If you guys want to know more about the statutory construction principles, take a look at the video Statutory Construction. She's just inventing these ideas. There's no citations here. She just doesn't think it works this way because she says so. We have another statute here that establishes that medical support of a child is an element of child support. We have another statute here that provides that child support unpaid on the date it is due becomes a judgment on that date by operation of law. Finally, the judge is using the law. Thank you. DCR 13.6 provides that factual contentions involved in a pretrial or post-trial motion shall be initially presented and heard upon the affidavits. The court can set the matter for a hearing at a time in the future and allow oral examination of the affiants to resolve factual disputes shown. We have another law here, which is Rule 12, Subsection 5, which provides that a decision on a motion shall be rendered without oral argument unless that oral argument is ordered by the court. And then we have the next section here. The court thinks that an evidentiary hearing is necessary for the court to resolve the factual conflict between the parties. Therefore, counsel for me shall within 10 days of the date of this order send a notice to counsel for my ex selecting a Tuesday, Wednesday, or Thursday between the hours of 9 and 12 to appear before Department 11 of the 2nd Judicial District Court and prove the case. Penalty for violation of order. This is a standard boilerplate penalty. The law requires that the judges in the family division include these in all orders that they entered. It just warns people to not abduct children because if they do so, they're going to be charged with criminal, I guess they call it abduction of a child or removal of a child or something like that. And then we've got a certificate of mailing, which is indicating that the court served both my attorney and my ex's attorney electronically. Going into the aftermath, I filed, it looks like 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 documents. They were not all free filings. 5 of those were subpoenas. So the cost of those subpoenas would be 5 times 26. That should be $131 if I have the math correctly. If not, it's up on the side, next to my head. That'll be the correct number. But those are the costs that I incurred with regards to those subpoenas. It's actually $26 plus 26 cents per mile, but I'm not going to bother with the 26 cents per mile computation because it's going to be such a small amount. Then we have my ex's attorney. She didn't file anything, so she incurred $0 in costs. Then I have my attorney. She would have only had to review the 2 orders at the very tail end of the case. And I guess she would have had to prepare the notice of entry of order. That's a boilerplate or standard document that's just kind of, their assistants do that. They just print it out and she signs it. And then the orders, those are procedural orders. There's nothing in there that really is altering the outcome or my rights. It's just setting hearings. So I think 15 minutes. I'm going to go ahead and have my attorney set at the rate of $500 an hour, even though that's slightly more than she charged. I think it's going to balance out the fact that my attorney was more expensive. And in the end, the amounts for attorney fees aren't really exact in this case anyway. I think that 15 minutes at a rate of at a rate of $500 an hour is reasonable. That's going to come to $125 in attorney fees for me. My ex's attorney, I think, would have spent probably 5 minutes on most of these documents. The 2 orders, I'm going to say 5 minutes each. All the subpoenas, 5 minutes each. That's going to be, 1, 2, 3, 4, 5, 6, 7 documents. 7 times 5, that's 35 minutes. I think the proof of service, that's going to be 1 minute, along with the request for submission and the other proof of service. I think, if you lump in all of the rest of the documents with the exception of the reply itself, I think it would be reasonable for that to come up to about 45 minutes for my ex's attorney. And then I think the reply itself should be sort of the last 15-minute block of time there, because as I've mentioned in previous videos, replies don't really require my ex-attorney to do any more work. All she really has to do is read it really quickly, take some notes, and kind of keep it in mind as stuff that might come up at the hearing. So I think 1 hour is reasonable for my ex's attorney under the circumstances, and at the rate of $250 an hour, that's going to come to $250 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post those questions down in the comments below, and I will see you guys next time.